Let's begin with Mr. Otten. Please be mindful of the clock.
Good afternoon, Councilmember Mendelson, Ms. Jacobs, and the committee of the whole. We're here to talk about the Office of Planning, which should really be called the Office of Purposeful Poor Planning. Really, this is, I'm here to represent the DC for Reasonable Development Coalition. You know, we heard earlier, we're an all-volunteer, non-hierarchical, unincorporated association here in the district. And unlike some of the smart growth advocates you might have heard earlier, we do not accept corporate contributions from developers. Some of those smart growth advocates talked about how the comprehensive plan is missing things like things to prevent gentrification of small businesses and residents. In fact, our comprehensive plan is one of the most progressive documents in the district and does specifically talk about that. Does OP follow it? I don't think so. A good example of that is in Adams Morgan with the hotel, where despite outcries of the surrounding residents and small businesses, OP would not meet with them. FOIA documents show that the Office of Planning staffers viewed citizens' concerns about displacement pressures from the hotel as annoying and something that should get ignored. And this scary and disrespectful sentiment was passed from the Office of Planning to the Zoning Commission, who towed the line and approved the luxury hotel project. Another issue is, you know, the zoning rewrite, of course. You know, they keep talking about how much time that they've had, 5-6 years, yet the number one priority in the district, housing affordability, wasn't touched at all in the zoning rewrite. The broken IZ mechanisms right now have not been fixed or addressed at all in the zoning rewrite. And the fact is, this is a clear indication that OP has lost its way, is not using best AICP, American Institute of Certified Planning practices in its review processes, and it shows that the city ought to have as a whole, ought to have a meaningful discussion about what is good planning and what are the characteristics of a good planner, because we know what bad planning is, and now that Harriet Trigoning is gone, we have this opportunity. To the zoning rewrite, I mean, disparate treatment. We have now on the record from the Office of Planning that they did meet with Georgetown over a series of years, two or more years, over several meetings to come to a compromise zoning regulations that protect that community from their broad sweeping changes that are affecting everywhere else. The zoning rewrite, taking away our rights to weigh in about development in our communities. Why would they do this? Corner stores we heard earlier. I mean, why take away something that deserves a hearing where community agencies and ANCs and the public get to weigh in and talk about development in their community? Why is that being taken away in the zoning rewrite? This is absolutely inane. And then finally, the zoning rewrite, the remapping that's going on. I mean, increasing densities and heights beyond current designations is a remapping of neighborhood zone designations. And that really needs to be looked at in terms of what that means legally. Remember, it wasn't until September of last year that the final version was submitted by OP for the public review. They could have had 50 years and millions of meetings, but it wasn't the final version of what they think is appropriate, wasn't set down until September, wasn't printed and put it into libraries until October of last year, and they wanted to shut the record in November. Luckily, we had 13 ANCs around the city submit official ANC resolutions asking for more time. We have more time, but in that more time, we were expecting a back and forth conversation, which I alluded to earlier. That has not happened. It doesn't happen at hearings, and it should happen in a direct, conscious way with a new planner at OP. Thank you.
Thank you, Mr. Otten. Ms. Sellin?
My name is Ann Sellin, and I live in Ward 2. This is not just an administrative text case. There's remapping embodied in this case. For instance, on 16th Street between Scott Circle and H Street, the heights go up 40 feet. In commercial zones, the footprint increases to 100%. This is a mapping case. This is a contested case, but it should be completely separated from an administrative case. The characterization of our zoning regulations as obsolete is false, Mr. Tregoning has said repeatedly that our code is obsolete, dating from '58, and hence it must be completely rewritten. In actuality, the zoning regulations have been continually rewritten over the past 55 years by the Zoning Commission. Just look at the text and you will see that hundreds of changes are spelled out by date in small letters throughout the text. New sections have been added, such as home occupations, PUDs changed, overlays added, all the commercial zones rewritten, new zones incorporated. The justification for this exercise is really based on the ideology of smart growth, which may be an excellent tool for sprawling suburbs, but is not appropriate in a largely built-up city. The proposed regulations originally meant to be easier to understand are extremely difficult to decipher, unlike the old ones. For example, it can take more than an hour to figure out what uses are permitted in an R4 residential district, that is, commercial uses in row houses, because of the convoluted tables, which must be cross-referenced. In the old regulations, you could figure this out in 3 minutes. The text is 300 pages longer than the old text and extremely confusing. In Dupont Circle, we have presently 13 different zones, making it very, very hard to comprehend what all the ramifications are in those various zones and how they're being changed. The presentations in neighborhoods by the planning staff have met with strong opposition, and there are just very few of those, by the way. I think just one in Dupont Circle. But little has been changed in the text in response. Now that there will be a new planning director, there should be a directive by the council that citizens' concerns be seriously taken into consideration and acted upon. Restrictive variances have wholesale been turned into special exceptions. Special exceptions have such vague and permissive allowances, they are virtually impossible for the BZA to turn down. The BZA never turns them down. Unlike variances that require a showing of unique conditions to the property. People invest a great deal in their homes and should have some assurance about the stability and protection of their investments. It is imperative that neighborhood citizens groups have party status in the regulations that they were formally given. Citizens care deeply about their neighborhoods, but with these regulations, they are denied meaningful legal participation to take a case to court. Because of the proposed changes that are so difficult to comprehend due to density, confusion, and conflict with a comprehensive plan, I believe that the process of the rewrite should be abandoned. Thank you.
Thank you. Ms. Armstrong.
Good afternoon, Chairman Mendelson. My name is Faye Armstrong. I'm a member of the Board of Trustees of the D.C. Preservation League, and I'm pleased to have the opportunity this afternoon to reflect upon the work of the Historic Preservation Office over the past year. First, we wish to commend David Maloney and the entire HPO staff on their high level of professionalism and commitment to protecting the many historic resources in the District of Columbia. The preservation community recognizes the broad responsibilities vested in HPO and the limited resources they have to meet these many demands. We call upon the Council to fully fund HPO and HPRB operating requirements. Among HPO's many accomplishments this past year, we would cite the preparation of a beautifully illustrated 4-year preservation plan extending through FY 2016, completion of design guidelines for Anacostia, George Washington West End, and Meridian Hill, and near completion of nomination for the George Washington West End Historic District, and development of a new placarding system to provide notice to neighbors of applications for building permits requiring review by HPRB. These activities were completed in addition to its regular review of thousands of permit applications. And in addition, they work with the DC Preservation League each year on the Awards for Excellence in Historic Preservation, which this past year attracted a record crowd of 550 attendees. It is against this background of significant challenges and achievements that we wish to express our concern about continuing gaps in the enforcement of laws related to historic preservation. In our testimony last year, we described in some detail longstanding problems with the enforcement of building codes and building permits in historic districts. We remain concerned at the lack of visible progress on these issues. Wherever a violation related to the exterior of an historic property is allowed to stand, it encourages violations on other properties, with the result being the gradual degradation of entire historic districts. It is time, in our view, for a new approach to enforcement within HPO. Additional resources are needed to support enforcement. However, as we have seen in the past, the problem cannot be resolved by simply adding more inspectors. We do not presume to have the prescription for the ideal organization, but we do question the effectiveness of a system that divides enforcement from review functions, particularly when so many enforcement problems relate to follow-through on design details that staff reviewers themselves develop or are given responsibility for by HPRB. Review and enforcement should be better integrated, and additional staff, which is needed, should support both functions. For there to be a deterrent effect on others, it's critical that enforcement be accompanied by public knowledge. However, the public is currently unable to follow an enforcement action from the time a violation is reported through any mitigation to a final resolution, including possibly payment of a fine. An information system with a public component is needed, which would require HPO to have computer capacity, which they do not appear to have at this time. We believe this would be a very worthy application of additional resources. This past year, we were pleased to be able to comment on the long-awaited draft regulations to implement the 2006 Demolition by Neglect Amendment to the 1979 Historic Preservation Law. However, as the law limits these new remedies to court cases, we would reiterate the need for closer coordination between HPO and DCRA in enforcement of building code provisions applicable to historic districts and historic landmarks, and by them with other interested agencies such as DHCD and OTR. As a practical matter, this daily coordination where remedies are to be found before it's too late, as the HPO likes to say in its own plan. You have some other comments from there in writing. I would also like to take this opportunity to say that the Preservation League reciprocally endorses the testimony today offered by the Committee of 100 on preservation issues. Thank you very much, sir.
Thank you. Ms. McCarty.
Hi, Chairman Mendelson. I'm Susan McCarty, and I'm just here as a citizen that's concerned about this whole rewrite of the zoning and kind of how it's playing out. I first became aware of it a few months ago, and I've attended some meetings, and I've been really dismayed because, I know there was this comprehensive plan, and that no one seemed to be paying attention to that anymore. And some of the zoning recommendations seem to me to have some negative implications, and I didn't see anywhere that there was any study of positive and negative long-term impacts of these things that are suggested, such as if you have a lot more density, you're going to have more crowded schools and classrooms, and, what was the plan for mitigating that problem? So, just like it hasn't just been very well thought out and thinking about long-term impacts. And then the other thing I noticed going to some of these meetings that was upsetting was I just felt like people were, the way the process was coming out, that it was polarizing people. You kind of had, you had the kind of the, for lack of a better word, the more of a smart group advocates that seemed to be younger, more urban, single or without children, and they were at the meetings, and then you had more of a middle-aged to older age group that were kind of clearly in disagreement with a lot of the things being proposed, and who seemed to be really absent at these meetings were the family, the people that have school-age children that would be greatly affected by some of the things that are being proposed, and they don't seem to be informed or have a voice. So it just seems like it was coming down to some kind of zero-sum game that just seemed like that's not the way a democracy or a good civic involvement should be evolving. And then the other thing that I was concerned about, there seems to be confusion too on the whole thing with lower income housing and affordability. I know I've heard at some of these meetings that people are understanding that if you have fewer parking spaces, then that means the units are cheaper, therefore there will be more housing for low income. But from what I've read or I'm looking at, it doesn't seem like developers are really making those units less expensive just because there are fewer parking places. So it doesn't sound like that, which is a very important part, I think, about development in cities, is including all kinds of economic people in that representation. That's it. Just wanted to say a little.
Thank you. I believe only one of you gave us a statement, written statement, Ms. Armstrong, and I will look at that more closely later. I don't think I have any questions for any of you. Ms. Armstrong, your testimony, I think, gets into resources, so that's something that is we'll be looking at when we come back with the budget.